Appeal versus Gerler. Ms. Gerler, are you there?
I am unmuted, Your Honor. This is Ms. Gerler, and my last three digits are 343.
Yes, ma'am. Are we on this case? This is set for non-jury trial. This was a termination action. Ms. Gerler, what's your defense to the termination? There's a month-to-month lease, correct?
Well, there was a change in agreement as well, Your Honor, and history and backstory that is very much applicable to this situation. I would like to first bring to your attention that I'm a lifelong, long-term renter. Residentially, longest term 13 years, and 8 years. Commercially, I leased an upstairs office at Nichols Arcade from Wilson White Management at that time for 15 years. I have never had a problem paying my bills or until COVID, and which I contracted in fall of 2019, which began a horrendous downhill slide of health, illness, income, and has basically rendered me indigent at age 68. I have tried to get help from agencies, and I have not even heard back from Hawk as to, after my appointment on Monday, as to, how things went. There are many issues beyond what is apparent on the ledger sheet, and when I initially agreed to move into this home, I had another one lined up as indicated previously in our hearing. I requested to stay only 3 months. The plaintiff demanded 6 months because she needed me to watch her home while she and her husband, the landlord, went to Florida for a very long vacation, over 6 weeks, I believe it was, in 2020, beginning of 2022. Problems arose right at the...
Ma'am, can I just stop you one moment?
Absolutely.
All right. This is filed as a termination action. And fundamentally, the issue is going to be because of there is no lease, is going to be, why shouldn't you move?
Your Honor, I've been before you previously, and I have 3 functional disabilities, electrohypersensitivity, which makes me incompatible with any of the wireless utility meters, internet, Wi-Fi, cell towers, etc. This home has also been mitigated for me with the acknowledgement and cooperation of the landlords who, years prior to my tenancy, had replaced the utility meters with opt-out meters when I made them aware of all the issues of electromagnetic frequencies. They have Ethernet installed, and we had things mitigated to reduce the interference of electricity and wireless devices, including Stetzer filters in the plugs of electrical plugs of the home, which was also by verbal agreement, my loan to them on their above floors for the use of the landline digital cable phone, and that which has been denied to me and does not allow me to send more information to the court. My impression from the papers that I was given, and as I indicated in the prior hearing, Judge Barr had said other ones needed to be entered that apparently were not needed. This is collection and termination. Had I had my phone line not turned off to me after I faxed in the confidential contact information requested by the court, I would have been able to send to you a letter from Ms. Peel that she wrote to the Department of Health and Human Services when I applied 3 years ago in 2020, stating that, I was in dire financial circumstances and having problems paying rent with the prior landlord. I did not know at that time I had long COVID. It was also the plaintiff who did the research and informed me in late spring of 2022. But they have awareness of all my frailties and vulnerabilities, which they have not been honoring in any degree, and knowing how very difficult it is for me to find a safe place to live, and I'm going to have to move rurally. There is no housing, affordable senior housing, et cetera, I can be in because of everybody else's need for wireless devices, which are beyond hazardous to me. I suffer from post-traumatic stress disorder from a car accident where when I requested aspirin, they wouldn't give it to me, but narcotics and opiates that were not compatible with me, and a closed head injury that was not diagnosed for 1.5 years. So I have 3 strikes against me just as a person functioning in the world with the long COVID, the electrohypersensitivity, and the PTSD. I have been subject to some very harsh, intrusive, invasive treatment as a tenant here for some time prior to these recent occurrences. And the assumption that one has of autonomy, privacy, and enjoyment of property when renting a property have also been denied me.
Okay, Ms. Gerler,
Yeah.
I'm going to stop you for a moment, okay?
Sure.
Those aren't a basis for me not to grant a judgment to the plaintiff, or at least possession. The issues that you're talking about may relate to their monetary claim. But as to the issue of possession, why shouldn't the landlord get their property back? Let me try to put it that way.
Your Honor, I was under the impression that Hawk and other agencies would be assisting me with the back rent so that I would have time to find a suitable place, because I will literally be on the street with my possessions. I would say that would be today's equivalent of delivering a head on a plate. I have nowhere to go. I have no vehicle. I live as a virtual shut-in with restrictions.
Okay, I understand that. Your name, ma'am?
Pamela Peel.
Okay. Ms. Peel, you've heard all those circumstances. You're aware with this defendant. How much time would you give her to vacate the premise?
Your Honor, I have asked her to pay up or move out since June of 2022. I am a very kind-hearted person. I was aware of the circumstance. However, this whole thing, I'm in my 70s. I depend on my rent for paying my bills. And I kept asking her, hoping, praying that she would leave. And she was unable to do so. And I can no longer carry her on my back.
All right.
Literally, it's.
I hear you, and I understand because of the pretrials in this case, where this case was. So how much is owing?
The amount of rent owing is $11,995. That's about.
Okay, right. So the problem for both of you is even if Ms. Gerler, and just listen to me, even if Hawk were to assist you, given what their maximum amounts that they would be able to assist, you'd still have to come up with $9,000. Okay? So there's part of that's the big issue. So when
Your
we
Honor,
get to that,
pardon?
pardon?
I would just need to inquire about those figures because when I spoke with Autumn on Monday, she said that they had, I believe, a maximum of $5,000 they can issue. She was going to reach out again to Faith in Action for me, whose monies Ms. Peel, the plaintiff, declined in July of 2022, and at that time, other affiliated agencies would have brought me current there was $2,985 owing, but because the plaintiff refused the offers of money, that other monies were not forthcoming. And the plaintiff also knows I have been sequentially ill on a regular basis. There's no soundproofing between the downstairs, upstairs. They hear me hack, cough, sneeze.
Ma'am?
So
Ma'am,
I'm letting you
Ms.
know
Gerler,
it is illness, chronic illness. Yes.
Ms. Gerler, whether it's 5,000, 3,000, we can get into that argument, but you'd still have to come up with the other 7,000 if it's 5,000. I mean, the problem is that those other amounts are going to be your difficulty.
Your Honor, I don't believe that I should be culpable and responsible for the monies they declined in July 2022, the $2,985, which would knock the equivalent of $3,000 off of the total. When I spoke to Autumn, she said that she would also pursue with Faith in Action. I was denied by Department of Health and Human Services for reasons I don't know, because my mail is being held and I have not gotten that back to me. When you're only making $1,100 a month on Social Security, I don't know why I was denied, Your Honor. I can no longer work. I was self-employed.
I understand that, Ms. Gerler. Ms. Gerler, I understand all of that. But when we all boil it down, the reality is the funds aren't there. And so if the funds aren't there, what's really going to end up happening is you're going to have to move. As I see it, and I'm looking at the case, it isn't a matter of whether or not you will have to, it's a matter of when.
And I would ask that the landlords, knowing my circumstances and situation, please grant some lenience in this case, as they may be leaving at the end of the month to go on a 2-month Florida vacation. I have tried even to get people to help me pack, and people are not available due to our upcoming holiday. I am at this point.
Okay, Ms. Gerler, let me ask you this.
I'm weak.
Ms. Gerler, In your mind, how much time do you need to move?
To be very
Not saying I'm going to
realistic,
give you
sir,
that much time. How much time? When could you be out?
to be realistic, sir, requiring the assistance and the fact that I may move very far away, I would likely need till the end of January because I have quite a bit of things to take with me.
Okay, so you need to the end of January.
Yes.
Ms. Field, would you give her to the end of January to move?
Consult with my husband for 1 minute.
You look like the brain trust, but yeah, go ahead. You can talk.
Would be willing to do January 15th.
Okay,
And
so you won't do
Your Honor,
January.
that's not possible. I
Hey,
apologize
Miss
for
Girl,
interrupting. It's not
Miss
possible,
Girl,
sir. Yeah.
Miss Gerler, hold on.
Yeah.
Anybody have anything else to say? Before I give you my ruling.
Your Honor, if there was anything else beyond hold on, I did not hear it. This is,
No, okay. I was just asking if anybody else wanted to say anything else before I issue my ruling.
Your Honor, I would like to say, if it is possible, they hold $995 as a security deposit, with which they could keep for the month of January if I were allowed to stay. And of course, we'll continue to look for additional help, but to pay. But they know my circumstances, and
Yes, they do, Miss Gerler. So here's what I'm going to do. I don't think that there's really much distinction between the 15th and the 31st. And given your circumstances, Miss Gerler, I'm going to grant a judgment to the plaintiff for possession. The writ will not issue till January 31st, 2024. There
thank
is
you
an
so
issue
much.
regarding, you're welcome, but there is an issue regarding monies that would be owed. And so a trial on any additional monies that will be owed will be set for March 5th, 2024 at 9 a.m. in person. That will give time. The reason I'm setting it out to that date, that will give time by the time she vacates the premises to then you can do the inspection and you can have all of the damages that we can figure out and hopefully have it totaled. All right. Any questions from
Your
either?
Honor, the only comment that I have to say, and I'm very sorry, but I cannot appear in person. I can only appear via remote Zoom
All right.
due to my disability.
I understand that, ma'am. All right. Yes, ma'am.
Your Honor, you've struggled getting into for many months now. Since I asked her to leave, pay up or leave from the possession that I filed a few months ago, October. The tenant has not paid us any rent, and she will not let us have access to our mechanical room, which unfortunately is, we have to have access to the mechanical room through her apartment. And we give her notices, and then we have people come, and she will not, oftentimes won't answer the door, or will just say, whatever excuse, and then we have to continually deal with it. That's why I really didn't want to extend the time, but I understand your perspective. It's been very difficult dealing with her. And
This is not great.
looking forward to this being completed. And I just want to, we do want access to our mechanic.
All right. Under paragraph 10,
Your Honor,
when you fill out. Yes, Ms. Gerler.
I would like to respond to that, please.
Which part?
The part about them wanting access to their mechanical room, or access to the apartment. I have been subjected to an increasing amount of hostile, threatening, aggressive action, pounding
Okay,
on
Miss
the door.
Miss Gerler.
I would allow them in to do whatever they need to do, but not by myself, with someone else. I have not resisted them. I have been literally ill when they wanted to
Okay,
come
so
in.
here's, Miss Gerler, here's what I'm gonna do. On the judgment form, when you fill that out at the counter, under paragraph 10, the defendant is to allow plaintiff access to the mechanical room upon 48 hours notice. Ms. Gerler, that will give you time to get somebody there. That's adequate notice that you, if you're gonna have somebody else go in and look, you got the time to do it.
Your Honor, that is totally fair, and I
Thank
am
you.
thankful.
That's what I do.
I'm very impressed with you, Your Honor, so thank you.
Well, thank you, Ms. Gerler. I appreciate that.
Will you put that in writing or do I need to?
You need to write that under paragraph 10 on the judgment form when you pick one up the front.
Okay. And what exactly do I have to say again?
Defendant, you know what? Go fill out the judgment form. I'll put it under paragraph 10. I got it. Okay.
I actually have it filled out, but this, it wasn't just for possession. This was.
There's a money portion of it too. It's, you wanted possession and you want a money judgment, or
So I can give you both of those.
you can give me the judgment form. The money judgment piece I've adjourned to March.
Okay, so then I don't fill out the money piece. All the rest is.
Do you have the,
I have a form. I didn't expect it.
okay, put the names on there. I'll fill the rest out.
Okay.
All right.
Thank you.
Thank you. Thank you, Ms. Gerler, and both of you have a very happy. Hang on, hold on, counsel. I'm not gonna worry about it at this point. I'm just trying to get through these. Come on. Your name?
Pamela Peel.
All right. Ms. Gerler here?
She's on the phone.
No, she's on the.
I do not know how this got muted again, Your Honor. I believed I was on unmute. I have been present.
You're good right
Nancy
now.
Rose there. Okay.
All right, where are you folks in regard to this case? Did you receive a copy of her answer?
Yes, I did. Yes, I received it on the 13th. So I'm the owner of the home at Way, Dexter, Michigan, where the defendant is now occupying the first floor. I'm very nervous in this setting, so that's why I wrote everything.
That's okay, me too. Go ahead.
Okay. I'm seeking possession of my property and I want the defendant to move out immediately. We have no lease. On September 23rd, 2021. The defendant and I made a month-to-month verbal rental agreement, and she agreed to pay $995 a month on the first day of each month following the first payment. On October 4th of this year, I gave the defendant the proper 30-day notice demanding possession of my property because of non-payment of rent.
Well, okay, let me stop you there.
Okay.
A 30-day can't be the subject of a non-payment of rent action.
Okay. So.
All right. Do you want her to move or are you just terminating her tenancy? I mean, are you terminating her tenancy and want her to move or do you want her to pay you?
I want her to move and I want to also have a money judgment. So I can't do that?
Yes, you can do that.
Okay, that's what I want.
Okay. Go ahead.
Yeah, and I'm seeking a money judgment from the court for all back that she owes me as of December 1st, 2023, which is $11,995 plus court costs $215 and service fee of $68.
So how much is your
So the total
claim?
money judgment requested from the court is $12,278.
All right, Ms. Gerler, what do you have to say to that?
Your Honor, when I first moved in, it was to be a temporary arrangement. I had another place lined up that did not end up being represented appropriately. It was to be vacated and renovated. Didn't happen. I have attempted along the way to give Ms. Peel, the plaintiff, money. I became extremely ill with COVID, which I have long COVID, along with 2 other disabilities. When I became behind in rent because of illness and sought help from local agencies, the plaintiff was offered money from Faith in Action, and she declined those monies. And there were other monies from other agencies that would have been available that would have satisfied my arrearages at that time of $2,985. Declining those monies led me to believe that she simply wanted me to move out. So I tried to start packing possessions, became ill with COVID again. I have, in the court documents, outlined to you the many times since then that I have been afflicted with every COVID variant. I already have a serious extreme condition of electrohypersensitivity that I cannot easily find a place to live. I cannot live in group settings, be exposed to Wi-Fi, wireless meters, be near cell towers. I need a rural environment. I no longer have a vehicle. I cannot use cell phones, smartphones, computers due to my electrohypersensitivity, and I thank the court for granting this Zoom appointment at the last minute, since I was not supplied the forms necessary in the personal and mailing service I received, and was actually waiting because in our December 1st hearing with Judge Barr, he informed the plaintiff that she had filed incorrect paperwork and needed to refile. So I have been waiting for that paperwork to come, which I don't know if something changed and was not necessary. But
What
am
incorrect
now,
paperwork? I don't have a notice to that.
Well, and that's whatever happened, Your Honor. That's what I heard in court, and I'm not privy to what happened thereafter. I am chronically ill, Your Honor. When I get well,
Ma'am, hold
I cannot
on.
work.
Yes, ma'am.
I spoke with my attorney counsel yesterday, and she said my paperwork was fine. I think it was just not clear to Judge Barr what I wanted because I didn't know how to present my case. So,
Well,
but
yeah, I actually see what Judge Barr is saying right now. Well, you filed 2 different notices. That's why. I got it. It's fine. I think. Hold on. That's not that one. Right. You filed 2 different ones, but you've got, it appears to me, the correct paperwork.
Your Honor,
So-
just to respond, that's what I heard from the judge. And my legal
Yeah, but
counsel,
this is another judge saying that that's wrong. It's correct.
and that's fine. I have no problem, but I was
Okay,
waiting
good.
on that paperwork. I know that the plaintiff is someone who tries to do things appropriately, but what did not happen appropriately with this home that has been a long time rental is that there is no certificate of compliance on file with the township. And the
Okay, so
application-
when are you going to move then?
Your Honor, I have had to deal with all the demands of the court, so I cannot explore that yet because I was required to apply for SER with the DHS, which was declined. I have contacted every agency available to me thus far.
Ma'am, do you understand she doesn't want you to pay rent and stay? She wants you to leave.
I understand that, sir, but to comply with the court and the paperwork required for this hearing, DHS, that's where I have put my first attentions. I have been packing and moving things out of the house, which they have witnessed, but because of my extreme sensitivities, it is not easy for me to find a place where I can live safely. I have just recovered from my last bout with COVID, which has severely impacted me for the last 4 years and created these issues. And I have also...
Ma'am, I understand all of that. The question becomes, when can you move?
That is a question mark to you and me both, Your Honor. I do not know. I have nowhere to go. I am solo in this world. I have no vehicle. My car broke down June of 2022. And my situation is not a good one because of chronic illness. My energy is not reliable. I'm sometimes 12 hours in the bed.
Okay, ma'am, I can appreciate all of that. But you also have to understand that the landlord is entitled to her premises back.
I understand that they request their premises back, and I have an appointment with Hawk on Monday. To what degree that will help, I do not know at this point. I have been unable to find assistance from anybody because they say I am not sustainable, because I am now forced to live only on my Social Security income, the house line.
Okay, ma'am. Here's what I'm going to do, because this has got to... I understand the difficulties that you're telling. I also understand that the landlord needs to resolve that. So I'm going to set this for a trial. You raised some issues in your answer, but I'm going to set it for a... Yes, ma'am.
When I talked to my attorney, she said that there is no requirement for the compliance regulations in Webster Township where I live. And she's an attorney from Dexter. So.
Oh, they know more. They know more than us
Oh.
here, us other country folk from Pittsfield, or what?
I guess. I don't know. That's what she said. Is that correct?
What?
That's what she said.
I don't know. I guess she's from Dexter, so she knows more than us.
Township does
We're
not
just
issue.
little country judges up here. Ma'am.
I actually called the zoning person too. She
Okay.
said-
And she said, yeah, probably
said-
she agreed.
I'm having difficulty hearing, Your Honor. Could that be repeated?
No. Okay. She went to Webster Township. The issue regarding the certificate of occupancy, it really isn't an issue because they don't require it for rental properties in Webster Township. That's the long and short of it.
I would like to know then why Legal Services of South Central Michigan gave me this form and checked
Okay,
it out.
ma'am, I don't know. You guys keep talking about lawyers. I've not met them. I don't know. All I know is this. You two are in front of me arguing a case. You have one position, plaintiff has another position. So here's what I'm going to do. I'm going to set this matter for non-jury trial. It will be in person.
Your Honor, that I hope you realize is not possible for me. I'm even being harmed waiting for 2.5 hours on my cell phone, which is on speaker remote
Ma'am,
from me.
then I don't know how I'm going to get you into court.
How is it not possible for me to continue in this manner, sir? I have been before you to establish the severity of my condition. I become debilitated, incapacitated, ill. I lived in the basement of my prior home for 7 months because of radiation poisoning, and by necessity, where your court is located, there are many electronic communication requirements for police, fire, the cell tower, Wi-Fi for the buildings. I will literally fry and be unable to move. That's why I couldn't come today. This is not a fun scenario. And the landlords are well aware of my conditions. They had mitigated the house. They used
Okay, all
Ethernet.
right, ma'am. All right, look. Do you have any problem if I hold a trial and she appears by Zoom?
I guess not. I've been without income for a long time, and my preference is.
Okay, look, folks.
Yeah.
There are a lot of folks out there that
Everyone
are
has
having a hard
sad
time,
story.
and I get it.
Yeah.
Okay, I have to deal with it every Friday, so I don't know that I can help you with any of that right now.
Right.
I'm just trying to set a trial date. Do you have any objection to her? What?
Tomorrow, the sooner the better.
I'm not coming in on Saturday. I'm this is not happening.
How about Monday?
No. What? We can do when? What time? 1 o'clock on Wednesday? Oh no, I can't do 1 o'clock. What time seriously can I do? Non-jury trial, December 20th, 2023. 9 a.m.
9 a.m. Okay.
And you need to appear in person, ma'am. You can appear via Zoom.
And right here?
Absolutely, that's where I'll be.
Okay.
And if I don't get this docket done, I'll be still sitting here from this one.
All right. Thank you.
Thank you.
Okay, thank you, Your Honor, for the accommodation for my disabilities. I appreciate your sensitivity to the matter and your humor.
Thank you, ma'am.
Bless you. I will sign off now.
All righty. Lakestone Apartments versus Leslie Lewis, recall. Where's Miss Lewis? She's not here.
This case highlights one of the most difficult realities courts face every day. On one side was a tenant dealing with serious health issues, financial hardship, and uncertainty about where she would live next. On the other side was a landlord who claimed she had waited years for rent payments and could no longer absorb the financial burden. Throughout the hearing, the judge repeatedly returned to the same legal principle. Personal hardship may explain a situation, but it doesn't automatically eliminate a property owner's legal rights. In the end, the landlord was granted possession, the tenant was given additional time until January 31st to vacate, and the issue of monetary damages was postponed for a later hearing. Cases like this remind us that courtroom decisions are often less about choosing heroes and villains and more about applying the law to difficult human circumstances. The result may not leave everyone happy, but the judge attempted to strike a balance between fairness, practicality, and legal obligation. What do you think about this ruling? Did the judge get it right, or should the tenant have been given even more time? Let us know in the comments below. And if you found this case as fascinating as we did, make sure to hit that like button, share this video with others, and don't forget to subscribe for more incredible courtroom breakdowns and legal drama every week.